Hi, everyone. Thank you so much for coming to this webinar about the life and legacy of Ruth Bader Ginsburg. Thank you to our panelists for being here, and thank you for spending part of your Saturday watching. We're going to kick it off by having Mrs. Page and Miss Borges, Hamilton Wyndham Regional High School history teachers, give a brief history about the RBG's early life and education.
Thank you, Olivia. We're really excited to be part of this webinar today. And Mrs. Page and I are both history teachers at Hamilton Wyndham Regional High School. And so we're going to go through a little bit about Ruth Bader Ginsburg's early education and her career, and really focusing on the historical context around what she experienced and what she was up against, as we kind of give you a brief timeline of her life. So I do want to start off with that hours after the announcement of Justice Ginsburg's death, the symbolic Fearless Girl statue, which I'm sure many of you are familiar with, it's installed in front of Wall Street's bronze charging bull, but since recently has been relocated to stand opposite the New York Stock Exchange, sported a new addition, and that was a lace collar. This tribute to equality and female empowerment figurehead Ruth Bader Ginsburg, of course, immediately went viral. And we know a lot about Ruth Bader Ginsburg because of her internet presence. And going viral was not new for notorious RBG. As RBG and images of her became an internet sensation over the past few years, scholars of the culture searched for an explanation for this phenomenon. And one Atlantic magazine writer, Dahlia Lithwick, wrote in 2019, "Today, more than ever, women starved for models of female influence, authenticity, dignity, and voice hold up an octogenarian justice as the embodiment of hope for an empowered future." And the leaders of today's webinar are ensuring us that hope continues. And so we would like to recognize our fearless leaders, Maya Beach, Mariana Kolbach, Nev Shekels, and Olivia Sulman, for putting this webinar together and bringing us all here today. The empowered future has arrived, and today's event is evidence to support that.
Ruth Joan Bader Ginsburg was born on March 15th, 1933 in Brooklyn, New York. She was the second child of Nathan and Celia. Ruth's older sister, Marilyn, died of meningitis when Ruth was a baby. Her father sold furs and hats, and in school, Ruth was a baton twirler, a cello player in the orchestra, and a member of the pep squad and the honor society. Ruth's mother took her on frequent trips to the library and instilled in her a devotion to learning. Her mother was diagnosed with cervical cancer while Ruth was in high school and passed away the day before her graduation. After the graduation ceremony that Ruth was unable to attend, her teachers brought many medals and awards to the house. During her remarks upon nomination to the Supreme Court, Ruth would acknowledge that her mother was the bravest and strongest person I have known, who was taken from me much too soon. I pray that I may be all that she would have been had she lived in an age when women could aspire and achieve, and daughters are cherished as much as sons. Ruth's mother, Celia, had been a very strong student in school and graduated high school at 15. She had been forced by her family to take a job in a garment factory in order to help her pay for her brother's education at Cornell University. She would marry young, as many women did at this time. Despite her conformity to the times, she strategically planned for her daughter to go further than she had been allowed to, saving a portion of the money her husband gave her every week for a secret college fund for Ruth. Ironically, Ruth would not need it. She was awarded a full scholarship to Cornell University, the same school her mother had worked to put her uncle through.
And as you can see, historical context is really important here to understand some of the obstacles that Ruth Bader Ginsburg was up against. As an undergraduate student at Cornell University, she met her husband, Martin Ginsburg, at age 17. She graduated from Cornell with a BA degree in government, on June 23rd, 1954. After graduating, they married in 1954. In that same year, her husband, Ginsburg, who was an ROTC officer in the Army Reserve, was called up for active duty and stationed in Oklahoma. Ruth Bader Ginsburg then took the civil service exam and qualified to be a claims adjuster. But after mentioning that she was 3 months pregnant with their daughter Jane, her civil service ranking was reduced, and with it, her title and pay. And so just think about that for a second, what these obstacles were for women as they tried to navigate these professional careers. Ginsburg, she learned a valuable lesson from this experience, and during her second pregnancy, which coincided with her first year as a professor at Rutgers University years later, she did everything that she could to conceal the fact that she was expecting. In the fall of 1956, Ginsburg enrolled at Harvard Law School, where she was one of only 9 women in a class of 543 men. Harvard only started enrolling women in 1950. And in a story that's really become part of Ginsburg's legend, the school's then dean asked women at a dinner party how they justified taking a place that would have gone to a man. And years later, when word got back to the Dean Griswold, who was the dean of Harvard Law School, that his former student enjoyed recounting this tale on the lecture circuit, he insisted that it had all been in good fun.
In 1959, Ginsburg transferred from Harvard to Columbia, where she would graduate at the top of her class. Despite glowing recommendations from several of her professors, none were able to secure her a clerkship with a federal judge. Ginsburg was finally able to get her foot in the door with a lower-ranking district court judge, Edmund Palmieri, and only after one of her mentors threatened to stop sending clerks his way if he turned her down. One of the judges that rejected her defended his decision, explaining, a woman's presence in his office would force him to limit his swearing. Oddly enough, she found herself regularly carpooling with her boss, Judge Palmieri, and the judge who made this statement. Ginsburg finally asked him why he felt like he could swear like a sailor during their car rides together, given that he had turned her down for a clerkship. Young lady, I'm not looking at you, he reportedly replied, staring straight ahead out the windshield. Looking back on the exchange years later, Ginsburg marveled, it was as if I wasn't even there.
And again, keeping with the historical context and how these experiences really shaped her early life and education, in 1965, Ginsburg was able to travel to Sweden for a local research project. And it was their early days in Sweden that Ginsburg said shaped her fight for women's equality. In Sweden, she witnessed a female judge 7 months pregnant presiding over a trial. In Swedish law school classrooms, at least 25% of the students that she saw were women. Two-income families were common. And even then, women were shouldered with the responsibility for children and housework. Women in Sweden started to debate this. It was questioned there, Ginsburg recalls, and she became friends with an author, Eva Moberg, who wrote columns in the Stockholm newspapers asking why women should have 2 jobs and the man only one. Moberg wrote, why should women alone be the one to take care of children for their medical checkups, buy them shoes, have dinner on the table at 7? He should do more to take out the garbage. And all of this made a significant impression on Ginsburg in realizing that there was still a long way to go in the United States.
So upon her return from Sweden in 1972, she took on the lead role as lead counsel for the ACLU Women's Rights Project. Ginsburg believed the most effective way to achieve lasting results was to pick cases that were winnable and would set precedents that would chip away at the legal barriers imposed on women. She would argue, not all feminist issues should be litigated right now because some are losers, given the current political climate, and could set back our efforts to develop favorable law. She concurred with other progressive legal minds of the time that one bad decision of the Supreme Court could have a terrible impact. During her time with the ACLU, Ginsburg would build, bit by bit, a legal foundation for women's equality. She theorized that this foundation would hold until society was ready to pass a more sweeping measure, such as the Equal Rights Amendment, which, if passed, would have explicitly banned gender discrimination. Ginsburg's slow and steady approach was not always welcomed by prominent feminists who felt the ACLU wasn't being bold enough. At this time, activists for women's equality, including Betty Friedan, Gloria Steinem, and Bella Abzug, were using a variety of strategies to demand change, including protests, marches, and legislative lobbying. For Ginsburg, a more pragmatic approach was in order. She would lay a foundation of equality that would begin to take aim at laws that were intended to protect women, laws based on stereotype notions of male and female abilities and needs.
And this actually morphed into a really brilliant strategy, and that was to represent men. In the early 1970s, decades before she joined the Supreme Court, her work as an attorney fundamentally changed the Supreme Court's approach to women's rights, and modern skepticism about sex-based policies stemmed in no small way from her lawyering. Ginsburg's work helped to change the way we all think about women and men, for that matter. And for Ginsburg, the gender of her plaintiff didn't matter. What really mattered was whether or not each case could potentially overturn laws restricting women's and men's roles. In 1974's Kahn versus Shevin, for example, Ginsburg represented a widower who believed he should be entitled to a Florida tax exemption granted only to widows. Although she lost this case, and that was the only case that she lost that she had argued before the Supreme Court, it showed an important aspect of her approach, her willingness to work on behalf of men, challenging gender discrimination. She reasoned that rigid attitudes about sex roles could harm everyone, and that all male Supreme Court might more easily get the point in cases involving male plaintiffs. And in 1975's Weinberger versus Weisenfeld, she argued on behalf of a widower, Stephen Weisenfeld, in challenging a Social Security Act provision that provided parental benefits only to widows with minor children. Weisenfeld's wife, a school teacher and primary earner for the family, had died in childbirth. Weisenfeld was denied her benefits, even though he faced all of the challenges of single parenthood. The Supreme Court gave Weisenfeld and Ginsburg the win in 1975, unanimously ruling that sex-based distinction was unconstitutional. 2 years later, Ginsburg successfully represented Leon Goldfarb in his challenge to another sex-based provision of the Social Security Act. These strategies, the strategy of representing men, ended up really getting the Supreme Court to try to start to shift their position in being more beneficial towards women's equality. Ginsburg was also wary of any laws that purported to shield women from the harsh world outside the home, such as rules barring women from jury service. As she wrote in her very first Supreme Court brief for 1971's Reed versus Reed, the pedestal upon which women have been placed has all too often, upon closer inspection, been revealed as a cage. And a little bit later, we have the honor of hearing directly from another one of Ginsburg's clients during this time period, Ms. Cohen.
Ruth Bader Ginsburg confessed in a 2014 magazine article that the 3 years between Justice Sandra Day O'Connor's retirement in 2006 and Sonia Sotomayor's appointment in 2009 were the worst times. She would say the image to the public entering the courtroom was of 8 men of a certain size, and then this little woman sitting off to the side. That was not a good image for the public to see. Sandra Day O'Connor had been the first woman appointed to the Supreme Court. She was nominated in 1981 by President Ronald Reagan. 12 years later, Ruth Bader Ginsburg would become the second with her appointment by President Bill Clinton. O'Connor and Ginsburg would serve 12 years together. They were even giving matching t-shirts by the National Association of Women Judges to help clear things up for anyone not accustomed to seeing 2 female faces looking down on them from the bench. "I'm Ruth, not Sandra," Ginsburg read, while O'Connor's proclaimed, "I'm Sandra, not Ruth." With the addition of Justice Sonia Sotomayor in 2009, Ginsburg would say, "With the three of us on the bench, I am no longer lonely, and my newest colleagues are no shrinking violets." It was at this point when she was asked at when there would be enough women on the court. Ginsburg consistently replied, "When there are 9. There'd be 9 men, and no one's ever raised a question about that."
And it's not too long after that that she began to find her voice on the Supreme Court and became known as the Great Dissenter. At her nomination ceremony, President Bill Clinton compared her legal work on behalf of women to the work of Thurgood Marshall on the behalf of African Americans. He said, "Many admirers of her work say that she is to the women's movement what former Supreme Court Justice Thurgood Marshall was to the movement for the rights of African Americans." And although her career as a litigator mirrored that of Thurgood Marshall, many scholars believe that her judicial legacy will place her among the court's so-called great dissenters: John Marshall Harlan, Oliver Wendell Holmes, and Louis D. Brandeis. In her book, Sisters in Law, How Sandra Day O'Connor and Ruth Bader Ginsburg Went to the Supreme Court and Changed the World, author Linda Hirschman wrote, "In disagreeing with their colleagues at the time they served among them, these legendary jurists anticipated every core development of 20th century judicial law: the dismantling of Jim Crow segregation, the protection of free speech, and the allowance of economic recognition." And starting in 2007, Ginsburg found her voice by speaking up when her conservative colleagues arrived at a decision Ginsburg believed to be regressive. Observers of these dissents argue that Ginsburg planted seeds of social progress, lending her powerful words to the movements that affected change from the ground up. And what about those collars? It was more than just a fashion statement. Ginsburg and O'Connor jointly decided that they would use jabots, which are these scarves, to carve out a visual space of their own in which would otherwise be a sea of black robes and ties. Ginsburg said, "You know, the standard robe is made for men because it has a place for the shirt to show and the tie." And Ginsburg told the Washington Post in 2009, "So Sandra Day O'Connor and I thought it would be appropriate if we included as part of our robe something typical of a woman." Ginsburg was known to break out 1 or 2 collars on decision days. A lace collar featuring gold trim and charms, a gift from one of her former clerks, served as her majority opinion collar, while a mirrored bib necklace she was gifted at Glamour's 2012 Women of the Year Awards is what she wore when her side had come up short. "It looks fitting for dissent," she explained after she broke it out for her 2014 Hobby Lobby opinion.
Despite their ideological differences, Ginsburg considered fellow jurist and conservative jurist Antonin Scalia her closest colleague. The two justices often dined together and attended the opera. They always shared New Year's Eve together with their family and friends, and Justice Scalia was very fond of Ginsburg's late husband's cooking. When Chief Justice John Roberts announced the death of Ruth's husband, Marty, from the bench in 2010, Scalia reportedly wiped tears from his eyes. "I've never heard them talk about anything political or ideological because there would be no point," Ginsburg's grandson, Paul Spira, told the Washington Post in 2016. "This seemingly odd pair had many things in common. They were both New Yorkers, close in age. They enjoyed the law, teaching, traveling. They enjoyed music, an evening spent with family and friends. Each was a child of immigrants. Yet they were also very different. She was Jewish and a woman. He was a staunch Catholic and Italian American. You'd be hard-pressed to find 2 more opposite views on the court." Ginsburg was a stalwart of liberal interpretations of the Constitution. Scalia was viewed as a strict conservative constitutionalist. Justice Scalia's son would write of these 2 best buddies. Those are Ginsburg's words. "What we can learn from the justices beyond how to be a friend is how to welcome debate and differences." The 2 justices had central roles in addressing some of the most divisive issues of the day, including cases on abortion. same-sex marriage, and who would be president. Not for a moment did one think the other should be condemned or ostracized. His son would continue, which doesn't mean that both justices didn't deep down believe the other was dead wrong. But they found a common bond in their tiny club of 9, each believing that what they were doing, arriving at their own opinions thoughtfully and advocating for them vigorously, was essential to the national good. I think we can all take a lesson from these relationships that Ruth Bader Ginsburg fostered, the love of the law and the love of our country that she inspired in all of us. Thank you, everybody.
Thank you.
Thank you both for providing, oh, hold on, let me turn my video. Thank you both for providing that important historical context and information on Ruth Bader Ginsburg's early life. So now we're going to move on to a presentation from Steve Harrington, the Executive Director of the North Shore Alliance of LGBTQ Youth, to talk about Ruth Bader Ginsburg's impact on the LGBTQ plus community. But first, I just want to remind everyone that if you have any questions at all, you can go ahead and put them in the chat, and we'll be sure to ask our panelists at the end. Steve, take it away. Thank you.
Okay, thank you, Olivia. Let me try to share my screen. And bear with me here for a second. Share screen, and we are going to share that. Can everybody see that okay?
Yep, we can see it.
Okay, great. Thank you. Thank you for inviting me. As Olivia mentioned, I'm the Executive Director of North Shore Alliance of LGBTQ Youth. We're located in Salem, Mass. And I'm not going to be able to stay on for the Q&A, but if anybody has any questions, they can email me at steve@nagly.org. So Ruth Bader Ginsburg certainly was a major, had a major effect on the LGBTQ community. She joined the majority on every decision in support of LGBTQ rights from the court and played a central role advancing the rights of queer people under the law. Among those rulings, one of the first ones was Romer v. Evans in 1996. Colorado had passed an anti-gay amendment restricting any sort of benefits for LGBTQ people. And after a lengthy litigation process, the US Supreme Court overturned that amendment, with Ginsburg joining a ruling declaring the amendment seems inexplicable by anything but animus towards the class that it affects. It lacks a rational relationship to legitimate state interests. Justices Scalia, Thomas, and Rehnquist dissented, and this I think is really telling of what the world was like and our country was like in 1996, with Scalia arguing that it was rational to withhold protections for queer people because their behavior was criminal, which it was at that time, astoundingly. But that homosexuality was criminalized would not remain the case for much longer, thanks in part to Ginsburg. In 2003, the court overturned the sodomy bans in the case of Lawrence v. Texas. Ginsburg once again joined the majority in finding that the criminalization of homosexuality was unconstitutional. This, surprisingly, was a case where two men were engaged in intimate contact, and the police actually came into their own apartment and arrested them for having consensual sex. So that was the case that was brought before the Supreme Court, and Ginsburg was one of the justices that fought to make sure that sodomy or homosexuality in the privacy of your own home was decriminalized. Amazing that it took till 2003 to have that happen. There were some states by that point who had decriminalized it, but this made it a national effect. Ginsburg also joined rulings that advanced same-sex marriage. including Windsor v. United States in 2013, which struck down the Anti-Gay Defense of Marriage Act, which surprisingly was passed during Bill Clinton's presidency. She also spoke for the majority in Hollingsworth v. Perry in 2013, which restored marriage equality to California after Proposition 8. At one point, California approved gay marriage, and the citizens of California voted on this Prop 8 to ban gay marriage. And this Hollingsworth v. Perry negated that vote. She also was important in Obergefell v. Hodges, which struck down state bans on same-sex marriage and extended full marriage equality throughout the country. This was quite a celebration. We in Massachusetts were very, very fortunate to have been the first state to legalize gay marriage in 2004. So that was, if any of you were around then, and you may have just been infants, that was the most celebratory day I think I've ever had in my life. And when it went national, this was the second time for us to celebrate. Justice Ginsburg wrote, "The Constitution promises liberty to all within its reach, and that same-sex couples ask for equal dignity in the eyes of the law. The Constitution grants them that right." She was unequivocal in all of her decisions about supporting LGBTQ rights. Not surprisingly, Ginsburg herself became the first Supreme Court justice to conduct a same-sex wedding, marrying Kennedy Center President Michael Kaiser and economist John Roberts in 2013. One of the final cases that Ginsburg took was Bostock versus Clayton County concerning a gay employee fired after he mentioned joining a gay softball league. This employee worked actually for the city, the county government in the Youth Justice Department, a very important position, and clearly someone dedicated to the rights and the health, mental health of young people. He mentioned on a Facebook post that he played in the gay softball league, and 3 months later he was fired. He sued, seeking to have sexual orientation and gender identity recognized as protected classes in the same way as race and disability. In the majority decision, of which Ginsburg was a part, the court found that the Civil Rights Act does indeed protect queer people. Ginsburg joined the decision which found anti-LGBTQ discrimination is a form of sex discrimination, thus illegal under Title VIII of the Civil Rights Act. The broad ruling grants protections to LGBTQ people wherever there are laws against sex discrimination, including employment, housing, healthcare, and education. When one of the cases that I haven't listed here was one you may have heard of a bakery who refused to bake a cake for a couple who wanted a wedding cake, claiming religious exemption because it was against her religion. It was that case was very, very interesting in that there were the bakery actually won that case, but not on the premise that their religious beliefs were violated. It was won on a very technical legal premise. One of the things that Justice Ginsburg enumerated, which was very, very interesting, there was another case of a bakery that would not make a cake that had an open Bible with a big red X in it. And the distinction that Ginsburg made was in the first case of the Bible, this was a cake that they did not want to make because of the cake itself. In the case of the marriage, the wedding cake, she said this was a cake that any other person could have come in and bought. So she was very, very distinct in the way that she argued her cases, and she was brilliant in the way that she argued them, much like what we already heard about arguing for men's rights in order to get women's rights progressed. When Justice Ginsburg died, certainly throughout the LGBTQ community, there was a lot of mourning and a lot of fear. And these are some of the reasons why. Justice Alito and Justice Thomas, within the last 2 weeks, have suggested that the Supreme Court reconsider legalizing same-sex marriage, saying the ruling had impeded religious freedom. 2 of the 5 justices from the majority in that case are no longer on the court. The Texas State Board of Social Work Examiners this week voted to change a section of its code of conduct that establishes when a social worker may refuse to serve someone. The code will no longer prohibit social workers from turning away clients on the basis of disability, sexual orientation, or gender identity. The High Court is also scheduled to hear cases challenging the Affordable Care Act, which will adversely affect many people, but many people within the LGBTQ community who have pre-existing conditions. The right to abortion and the legal reasoning supporting the right to bodily privacy are also under threat, not only potentially harming women and trans, gender nonconforming, and non-binary people, but everyone seeking reproductive health care. These are just 3 of the reasons why we are concerned that Ruth Bader Ginsburg is no longer on the court. I did find some wonderful quotes that give us a little bit of insight into why she was such a spectacular human being. People ask me, if you could be whatever you wanted to be, what would you be? My first answer is not a great lawyer. It is, I would be a great diva. But I totally lack that talent, so the next best thing is the law. Another wonderful quote, if you're a boy and you like teaching, you like nursing, you'd like to have a doll, that's okay. We should each be free to develop our own talents, whatever they may be, and not be held back by artificial barriers. And here's a real important one. If you are neutral in situations of injustice, you have chosen to side with the oppressors. Ruth Bader Ginsburg, you will be missed. Thank you so much for supporting the LGBTQ community in all the ways that you have, and let's hope your legacy remains for decades and centuries to come. Thank you all.
Thank you for that presentation, Steve. Yeah, it is very important that, we think about the legacy of Ruth Bader Ginsburg when we decide what actions or inactions we continue to take. Now I'm going to turn it over to Nicholas Rustino, a Hamilton Wenham High School history teacher, who will be interviewing Sharon Cohen, who is a former U.S. Air Force physical therapist and was represented by Ruth Bader Ginsburg in a landmark Supreme Court case.
Good afternoon. Thank you for that introduction. My name is Nicholas Rustino, and I'm a history teacher at the high school. I actually taught Olivia last year, and I'm very proud to be part of this fantastic event. I'm very happy to be here, and I'm really proud of the work that you kids and everybody else have done to put this together. This is a great afternoon. So my first question to Sharon Cohen is just to please tell us about the case that the late justice argued on your behalf as amicus curiae. I'm sorry if I get that wrong in terms of my Latin pronunciation. My high school Latin teacher will be very upset with me over that. But please, could you tell us about the case that was argued on your behalf? Oh, you're muted.
Am I there?
Yep, now you're here.
Okay, I can't see myself, so that's probably a good thing. You want to know about the case?
Yes.
50 years ago, which was just like yesterday, 50 years ago, I was 23. I was in the Air Force. I got married. I had the expectation that I would get a housing allowance, like all the men working with me did, and I did not get it. I could not get it. I went to everybody I could think of. I wasn't intending to file a lawsuit. I just wanted my housing allowance. But I went to a law firm. I was stationed in Montgomery, Alabama, and there was a law firm that did civil rights work there, Levin and Dees, that during the course of the time they handled the lawsuit would morph into the Southern Poverty Law Center. But Joe Levin took my case to a district court in Alabama, and we lost. I was gobsmacked that we lost. But of the three judges, one clearly said it was unfair that because I was a woman, I didn't get a married housing allowance because there was an expectation my husband would be earning the money to take care of us. The other two judges said, yeah, it's kind of unfair, but there are enough women in the service. There were, I think, 6,000 married women at the time. So it would cost the government too much money to give them automatically the housing allowance. On the other hand, there was in excess of 1 million married men in the service, and it would be too onerous to make them prove that their wives were indeed dependent on them. So the line from the earlier court was, women aren't being denied a right, men are just being given a windfall. From that loss, the next court was the Supreme Court, and Joe Levin, the Southern Poverty Law Center, took it to the Supreme Court. And at that time, the ACLU got very, very interested. If you saw the movie that CNN put out a couple of years ago, they said, we saw this case and we wanted in on it because it was, a clear-cut gender and equity case. So Ruth Ginsburg was not actually my lawyer. Joe Levin continued to be my lawyer of record through the whole thing, but she wrote the amicus brief, and he gave her part of his time to argue, and they went to the Supreme Court and they argued two different visions of the case. Joe argued a very narrow, this statute is unconstitutional. And Ruth Bader Ginsburg argued all statutes like this are unconstitutional. The decision was 8-1. The head of the Supreme Court, Rehnquist, said it was just fine to continue this kind of discrimination in the service. The other, it was 7-1. The other 6 split. 3 of them decided in the very narrow way that this one statute was wrong. And they did that, they said, because the Equal Rights Amendment was about to pass. And they didn't want to trample all over what people were doing democratically. And then, of course, the Equal Rights Amendment went down in flames. And the other 3 said that this was an example of statutes that are suspect, that all statutes like this are suspect, unless the government can come up with a very, very good reason to treat men and women differently. So that was the case. And it was oddly enough, it was Justice Ginsburg's first time arguing in front of the Supreme Court, but it wasn't technically her first case. That was Weinberger v. Weisenfeld.
Now, what stands out in your memory about her work on your behalf? What was your lasting memory of and takeaway from her work?
I think the biggest thing in my mind about that has already been mentioned by the first 2 women, Miss Page and Miss Borges, which was that line that she used that then Justice Brennan used when he wrote the majority decision, which is romantic paternalism serves not to put women on a pedestal, but in a cage. And that has been an important part of my thinking anytime I think about any group of people who are being protected for their own good, who who are any of us to say that we know what's best for that group of people? And it usually is a cloak for some kind of discrimination.
Now, in terms of your experience, I mean, I certainly have never had a case argued in front of the Supreme Court and can't foresee a circumstance under which it would occur. What was it like? What was it like to hear your case argued in front of the Supreme Court?
I wasn't there. I was not there. And because I didn't know I could be there. I was, and I want to make this case, I was really young. I was 23 when I filed and 25 when it went to the Supreme Court. And even for being young, I was young. I was naive. I came from a background. I wasn't very sophisticated. I'm not very sophisticated now, but I was certainly not very sophisticated then. And not very long ago, within the last couple of months, Joe Levin, my lawyer, called me up and he said, you know, I want to say something to you that's bothered me for a long, long time. He said, I didn't invite you to be in the Supreme Court because I didn't know you could be there. And I laughed. Joe, who's a friend of mine now, he was 4 years older than I was. I was 23, he was 27, and he was 29 when he argued this case in front of the Supreme Court. He was 29, and the woman he was arguing beside was 10 years his senior, and she'd been in some fairly lofty circles. You know, she'd been to Harvard, she'd been to Columbia, she was with the ACLU. We were young then. We were really young. And I think that when I think about young people, I think that I would like to tell young people that there's a great deal of freedom in being young. You know, it's a time to go out there and do things. You don't have a family. You don't have to keep your health insurance because, you know, your children are going to need it. It's a time of really great freedom to do what's right in the world.
Now, I think that's a great message. I really encourage my students, anybody out there watching, to, you know, take some risks and take some chances, because you never know what you're going to learn from the experience, and you never know who could be helped along the way. Right. Now, I look at your case. It was 1973.
Yeah.
And there was a lot going on at that time. You had the women's liberation movement. You had civil rights movements of various sorts. You had the Vietnam era. We were only a year away from Richard Nixon resigning the presidency. And your case was decided in May of 73. That was a month before my own parents got married. So, you know, talk about context, you know, that just a month later, you know, my own life could be shaped by this decision and similar ones like it. How do you feel your case fits into this moment in American history, this momentous time in our history?
Yeah, well, I think it did come at a time of a lot of upheaval. I think change happens during upheaval. You know, it doesn't happen when people are happy. It happens when people are agitated, angry, unhappy, stressed. People are stepping up into new positions, or people are being pushed and they're angry about that and they're pushing back, which is exactly what we have now. It's frightening. I mean, I think changes like this are frightening, but they're also meaningful and exhilarating. I think that my time of feminism, my being young during a peak time of feminism, corresponds to the Me Too movement. And old feminists like me were so exhilarated by the Me Too movement. You know, the feminism had reached a peak, and then we got some of the goals we wanted. We got some of those lawsuits we wanted, thanks to people like Ruth Ginsburg and Joe Levin. Things became okay. We went home, we raised children, we had jobs, we had lives. things had settled down, and to have it kind of blossom again, and blossom for a real reason. Me Too was fabulous, fabulous. Do you want me to go on about that?
Yeah, well, that my last question is the one I think we'd wind up spending the most time on. So that dovetails nicely with what are the lessons and the takeaways that somebody that wants to be active today can learn from your case in the career of Justice Ginsburg? What wisdom would you share with somebody that wants to get active today?
I think you do what you are good at and you're interested in. I think you don't have to be an activist. You don't have to be Ruth Bader Ginsburg. It would be very difficult to be Ruth Bader Ginsburg, quite frankly. You don't have to be a lawyer. You can use your talents in a lot of different ways. The only thing that's essential, I think, for making the world a better place is to do what you can with the next step that comes up. I do want to go back to the Me Too movement for a minute to say also that the exciting thing about the Me Too movement was not just that women were saying, you can't treat me this way. It was that other women were saying, you can't treat her that way. The whole impetus for Me Too was that women who were saying, I've been abused, I've been denied jobs, I've been sexually abused, and being called liars, and women saying, no, she's not a liar. I know this, it happened to me too. One of the essential parts of activism for me is not to grab a flag and mount the barricade, but to watch out for the guys on your left and right, to be part of that, to be not alone, and make sure other people aren't alone.
Yeah. So that notion of solidarity. Do you feel that your case in that moment in history is one of those things that if somebody's looking back at it now and is considering being active or joining a cause that kind of encourages that kind of solidarity, like you paved the way for other people and was part of this broader movement of women and men saying, we want gender equity and we don't want mistreatment or paternalism in that regard.
Do I think my case was important? Was that the question?
So in terms of you just mentioned that a lesson or a takeaway for activists is looking out for the people on your left and right flank and being part of that movement where you're giving credence to the experiences and lived experiences of other people. Mm-hmm. Do you feel like looking back on your case in that moment in history, that tumultuous moment, that a lesson for today is, you pursued your case, there were other cases that were pursued, and look at the advancements we have. That's a lesson and a takeaway for people today.
Yeah, it is. I mean, I would encourage people to step up and say, I can't be treated that way. And I know I've met a lot of people. I do a lot of panels and stuff like that. And people have said, I'm not the kind of person who would sue. And I understand that. There are people, it hasn't been entirely pleasant it wasn't pleasant back then. I mean, people were angry. And it isn't entirely pleasant now to have people come up to me and say, I know exactly how you feel and why you did it, which is probably the stupidest thing you can say to somebody else. No, they don't know. It's one way to go. You can sue. But you also don't have to sue. I know there are people who don't want to put themselves in that place. You have to have a certain personality to go and do that. But you can do other things. You can go to a rally. You can take care of somebody's children so they can go to a rally. You can write. You can, make art. You can just believe in being a decent human being to others. Yeah.
Sharon Cohen, I think that's a perfect end note for our segment of this webinar. I really hope that a lot of my students were watching and listening to that message. There's a lot of different things that you can do to get involved and stand up for other people. So I thank you so very much. The case is Frontier versus Richardson, decided in 1973. Sharon Cohen, thank you very, very much.
Thank you.
Yeah, thank you both for being here. And yeah, it is a powerful reminder that we need to stand up for things that we believe in. I'm just going to take also this opportunity to, if you want to stand up for things that you believe in, feel free to join the HW Human Rights Coalition at hwhumanrights.org. So now I'm going to pass it on to Annalise Bubar, a middle school student, who will be interviewing Christine de Lima, who is a middle school drama and public speaking teacher.
Hello, I'm Annalise and I'm 7th grade, and I'm going to be interviewing Ms. de Lima on the impact that Ruth Bader Ginsburg had on gender equality and women's rights. My first question is, how did you first hear about Ruth Bader Ginsburg?
Hi, Annalise. It's so nice to see you. Thank you guys for having me. Thank you, Olivia, for doing such a good job running this session today. It's been incredible. I think I've always had an awareness of Ruth Bader Ginsburg as a woman on the Supreme Court, much like I did with Sandra Day O'Connor, but I think I really became more aware of her specifically and what she stood for and her background once she was sort of catapulted into this cultural icon that we know her as today, this notorious RBG. In 2013, the Supreme Court had made a decision to put on hold a piece of civil rights legislation that protected and policed voter discrimination. And she dissented on that. And the public, especially young people, really got behind her and supported her and celebrated her for dissenting. And I think that's really when young people started to take notice of her and also really started to understand the importance of government and how decisions made in the Supreme Court impact their daily lives. So I think that's when I really began to learn more about her.
My next question I have is, what impact did Ruth Bader Ginsburg have on your life and your career choices?
I think when I really started to learn more about her, I had settled into and been in my career, but she certainly has impacted my life as a woman. So many things that she has worked towards, I reap the benefit from today. She made it unconstitutional for state-funded institutions to exclude women. She made sure that a woman could apply for a mortgage or a credit card without having to have a male co-signer. She has made strides for equal pay in the workplace. She has made sure that women cannot be discriminated against for being pregnant in the workforce. She has ensured that women are able to serve on juries. So all of these things are part of my life that I am so grateful to have.
All right. Have you ever faced discrimination when getting a job or any time in your life because of your gender?
I feel like my knee-jerk reaction to that is no, because I'm in a field that is predominantly and historically completed by women. But I wonder about the gender bias that has sort of influenced that for me. I wonder whether I've been pulled to this career because I have spent my whole life going to school with female educators. So it's hard to know, but I wonder whether or not being exposed to that as a field for women had some sort of impact on my choice to pursue it. I also think about when I was in high school, I worked at a concession stand at a beach, and it made me uncomfortable at the time, but I don't think I assigned it as discrimination. But I applied actually to be a cook, someone who would run the grill and the fry-later. And the manager there said, that's not something that women do. The girls run the front, you serve everyone, and the boys will cook in the back because girls get better tips. And it made me uncomfortable. And I worked there for 2 summers anyway, but it's not something I realized was a form of discrimination at the time.
Yes, that does seem like something that would be discriminating against women. What impacts have you seen that she has had on the whole country?
I would say, thinking about the whole country, there's certainly people who very much disagree with her opinions and things that she has fought for. But I think that across party lines, Ruth Bader Ginsburg is someone who is seen as a great thinker. As a teacher, I am a person who wants to teach young people not what to think, but how to think. And she is such a powerful example of a person who knows how to think. She is so thoughtful and so intelligent, and people who disagree with her on both party sides have a great respect and appreciation for how she is able to use her voice. I think when she was voted into the Supreme Court, it was a vote of 96-3. And there were Republicans who were openly against what she believed in, but had such a great admiration and respect for her intelligence. So in that way, she's really influenced and been admired by both sides of our government.
Do you think that she will continue to impact what people think about gender and women's rights, even though she's no longer here?
Absolutely. I think she has done so much for women's rights and for equality. And now that women have experienced those freedoms and those rights, it's not something we're going to let go easy, right? So we get to appreciate and enjoy these freedoms. And if there's ever a time where those freedoms are taken away or attempted to be taken away, it's something that we know to fight for, right? We've experienced it and we don't want to let it go. So I don't think that people are going to let her impact on the world slip away.
Is there anything else that you would like to share or talk about the impact that she had on gender equality and women's rights?
I think that something that I really appreciate her as a public speaking teacher is the fact that she wasn't the biggest and loudest voice in the room, that Ruth Bader Ginsburg was a person who was shy. She was quiet, she was soft-spoken, and she wasn't a dominating presence in terms of her voice or her stature in a room, but she still had an incredible impact. And I think that's a really valuable lesson for anybody, but particularly students. Young people aren't often seen as someone who might have a powerful voice, and she's such a powerful example of quiet power. You don't have to be the biggest or strongest voice in the room for your voice to really count and matter and make a difference. And that is something that I really value about her.
Thank you very much, Ms. Lima.
Thank you so much for having me, Annalise. Thank you.
Yeah, thank you, Annalise and Ms. Lima. And yeah, a great reminder that sometimes quiet power is better than yelling over everyone. So now I'm going to turn it over to H.C. Robinson, who is a Northeastern law professor and the vice president of the newly formed North Shore NAACP.
Hi, Olivia. Hi, everybody. It's so nice to see you, and it's an honor to be participating in this important tribute to Ruth Bader Ginsburg. I can tell that I'm in the presence of both great teachers and great students, so I'm honored to be a part of that. So what I wanted to speak to you about today, which I think actually does tie into Mr. Ristiano's question as he finished his discussion with Ms. Cohen about what people can do, how do we move forward in the context of a great loss of an individual person? So I hope in my remarks that I can shed some light on the function of the Supreme Court in our constitutional system as envisioned by the founders and the drafters of that document, and as it was lived and enacted in the course of her work by Ruth Bader Ginsburg. So I'm interested in helping to draw for you an understanding, or hopefully produce an understanding of how Ruth Bader Ginsburg was able, using the institution, the constitutional institution of the Supreme Court, to make the impacts that she made. And I hope that that should encourage us, because it suggests that another person can come along to occupy that role, that there will be people that come afterwards that can use this wonderful constitutional institution that we have, the Supreme Court, to make change in a positive direction to produce a better America. So I'm going to share some slides with you. So our constitutional system is, just going to wait for my slides to show. Okay. So our constitutional system is established by the United States Constitution in 1787. It's not the first founding document that we had, because of course, after we declared our independence under what would become constitutional principles in the Declaration of Independence in 1776, we had the Articles of Confederation, which kind of loosely brought the colonies that had declared their independence together after we won the war against the British. And it was understood that there was a kind of aspects lacking in the Articles of Confederation. For example, each former colony, each state had its own money. I saw some Connecticut money a couple of years ago in a friend's house that had just been left in the attic somewhere. And so they were sort of loosely confederated set of newly minted states. There were no provisions for a national army. There was no central government to establish things like post offices, roads, a national military, national taxation, or a national system of money. And the Constitution that we got in 1787 does all of those things. And among that, it distributes those responsibilities of government to specific branches. So we call this separation of powers. And the three branches of government that are established by the 1787 Constitution to generate a central government, which had been absent in the Articles of Confederation phase, those branches are established by Articles 1, 2, and 3 of the Constitution. So it begins, we the people, in order to sort of put together a better nation, are going to create a system of central government. Article 1 establishes the legislative branch. Article 2 establishes the presidency, so a unitary executive that will execute the laws that are legislated or drafted by the Article 1 branch, which is a bicameral branch. We know that. It has a House of Representatives and a Senate. And Article 3 establishes the Supreme Court. And it is the judicial body that will interpret the laws that are made by the legislature when they are coming into dispute among the citizens or between the government and its citizens. So in order for the Supreme Court's work to be generated, there has to be a case or a controversy, something that's disputed. The third article of the United States Constitution doesn't actually call for any other court than the Supreme Court to be established. But as we now know as 21st century people, there's no way that the one Supreme Court could do all the business of interpreting the federal laws in the United States Constitution. Article 3 has a provision that allows for the Congress to establish other courts underneath the Supreme Court, which will be the Supreme Court of all the courts in the federal system in the land. And we know that now there are 94 federal district courts that are organized into 12 federal circuits. So there are circuit courts of appeal across those 12 regions. And when those cases at the district court level are appealed to the 12 circuit courts and then appealed again to the Supreme Court can grant what's called certiorari review, or discretionary review, to hear those cases. So we've heard from some litigants before the Supreme Court, some parties that brought a case or a controversy here in our discussion today, and those were cases that the Supreme Court decided to hear. So what's the difference between these three branches that's interesting, that facilitated Ruth Bader Ginsburg's great impact on our nation and on the lives of Americans, some of whom we've heard from today? It's the fact that the Article 3 branch that establishes the Supreme Court and the rest of the federal courts now in our contemporary times is counter-majoritarian. So we have elected bodies in the Congress. We elect people to the House of Representatives and to the Senate in a majoritarian system, or a system in which the most popular people win. We're in the context of an election right now, and we hear in the news, so-and-so is so many points, percentage points ahead of so-and-so. That's about majority, the concept of majority, that the person who convinces the most people wins or gets into office. And we know the presidency is established in the same way, that it's, elected majorities. There's a electoral college, which we're not going to get into because it's not our subject matter for today, but those are majority branches where you have to be popular in order to win and to get power within those articles. The Supreme Court is counter-majoritarian, if you will, or it has a different quality to it, because justices to the Supreme Court are not elected. They are appointed by the president and approved by the Senate. And we're in that process right now with regard to the appointment by Donald Trump of Amy Coney Barrett. So what's significant about that? Why would the founders have established two majoritarian branches where the popular people get in, and one in which not only is it an appointed person that is never elected, so the 9 justices of the Supreme Court, but they serve for life tenure, so they cannot be fired except for like extreme cases of corruption, which we don't have, contemporary examples of certainly, and their salaries can't be reduced. So there are very few majority pressures on the Supreme Court, even though in the context of Supreme Court appointment hearings, we often talk about the court like it's a political body. We talk about conservative and liberal justices. But the structural nature of the Article 3 court, the Supreme Court, is that it is resistant to majority pressures. Because once the judges are there, they can act as they will or according to their conscience, because their salaries can't be reduced and they cannot be fired just on the basis of being, for example, unpopular in their decision making. So the idea of these features in the Supreme Court, life tenure, appointment instead of election, and that their salaries can't be reduced, was the idea that the founders had that you needed a branch of government to protect the rights of unpopular minorities, of people who may not have a majority across the entire population, but whose rights, as enshrined in the Bill of Rights, for example, the First Amendment to freedom of speech, the Fifth Amendment to not incriminate yourself in front of a court or a legal officer, rights against cruel and unusual punishment, that in order for those rights to be important and meaningful in our constitutional system and in our country, that there had to be somebody to protect those rights, even when the person asserting them didn't have a majority, enough people that were like them to be able to influence the other branches of government, to say, hey, if you oppress us, we're going to pull you out of office. We're going to vote you out of office, as is possible in the Article 1 branch, the legislature, the Congress, and the Article 2 branch, the president. So the neutrality of the Supreme Court, the idea that people who don't, wear even ordinary clothing to do their job, they wear neutral Black robes. There's nothing about how they express themselves in their dress that conveys, even anything necessarily particular about them as people, although we've had this wonderful explanation earlier in our event today about the significance of Ruth Bader Ginsburg, who's pictured here, her choice of various, ways of wearing something over the robe that signified her individuality. Sonia Sotomayor wears some very interesting earrings. You can go look at those. But the neutrality of the robes of the Article 3 branch, not trying to be popular because they don't need to be. They're protected by the structure of Article 3, and therefore they can protect other unpopular minorities. And we see that actually life tenure has an impact, and this kind of structural feature of the Article 3 branch of the Supreme Court in where justices go over time, so how they evolve over the course of their careers. Here I've put photos of 2 justices to the Supreme Court, Sandra Day O'Connor on the left and now Chief Justice John Roberts on the right, who were appointed by Republican presidents and who both have moved significantly to the center left over the course of their judicial careers. So this is an explanation of how the special features of Article 3, that once you are appointed to the Supreme Court, you don't really need to care about staying popular, can influence or can generate a particular course of decision making that may actually run counter to the party platform of the president that appointed them. So what I'd like to do in the second half of my time here is to ask you to think about that structural aspect of the Supreme Court and the notion of having a kind of, within a democracy, a majority-based rule of law and governance, one interesting branch that is, if you will, counter-majoritarian, and what function that feature can rather how a justice, and we'll look at three Ruth Bader Ginsburg opinions, how a justice can use that feature of the court, its kind of counter-majoritarian aspect, to do good things for what might be considered to be unpopular majorities. And by unpopular, I just mean people whose viewpoints aren't widespread enough that they can influence the majority branches, the ones in which you have to be popular in order to win. You have to get a lot of people to agree with you to nonetheless advance some very important values in our society. So we'll look at three significant decisions, or I'd like to walk you through three significant Supreme Court decisions where Justice Ginsburg either authored the opinion or convinced her colleagues to decide in favor of an unpopular minority on constitutional grounds. So first, the case of United States versus Virginia. This is a case from the mid-1990s that had been winding its way up through the federal court system from the beginning of the 90s. It was decided 7-1 in favor of the plaintiff, the United States in this case. There were 8 justices who weighed in on this opinion because Justice Clarence Thomas recused himself. His son was a student at the Virginia Military Institute, or VMI, who's the defendant in this case, at the time that it was decided. The one dissenting justice was Antonin Scalia. When the case was winding its way through the courts, the Virginia Military Institute was the last remaining all-male public undergraduate college or university in the country. And the United States filed suit during the Clinton administration against the school, arguing that excluding women from the Virginia Military Institute, or VMI, violated the Equal Protection Clause of the 14th Amendment of the Constitution. So the 13th and the 14th Amendments are added to the Bill of Rights after the Civil War is won during the Civil War. They eliminate slavery on the one hand, so the 13th Amendment makes it unlawful to enslave another human being or to own another human being as property in the United States. But then the 14th Amendment, importantly, extends the equal protection of the laws of all the other rights in the Bill of Rights to the Constitution and all the rest of the federal laws to the newly emancipated slaves. So under this 14th Amendment of the Constitution, we have this equal protection of the laws clause, and the United States is arguing that VMI's all-male admissions policy violates that equal protection clause. The state of Virginia argues, so the state of Virginia is the public authority that's funding the school, the Virginia Military Institute, argues that women weren't properly suited for the rigorous training that it was required to succeed at the school, but also argued, in fact, that the state had created a separate military program for women at a women's only school in Virginia. So this was an assertion of an argument that was literally 100 years old from Plessy v. Ferguson, the separate but equal decision that established Jim Crow legally in the United States until the idea of separate but equal in racial accommodations. So Jim Crow was a set of laws that said you could separate Black people and white people in the United States as long as there were separate but equal accommodations, which in practice were rarely, if ever, equal. In Brown v. the Board of Education in 1954, the decision that desegregated public education in the United States at the secondary school level, that notion that had been advanced in Plessy v. Ferguson in the later part of the 1900s, of the 1800s, that decision was undercut. So here we see that idea of separate but equal arising again in the 1990s in this Virginia case. Ruth Bader Ginsburg wrote the majority opinion, striking down the all-male admission policy at VMI, and this is what she said: that Virginia maintains that these differences in how the education is administered, the military education in Virginia, are justified by differences between men and women in their learning and in their developmental needs, like their physicality, their ability to do physical things. Then she wrote that generalizations about the way women are just estimates of what's appropriate for most women, and they don't justify denying opportunity to women whose talent and capacity place them outside of the average. That the other program, the all-female program, did not qualify as equal, that it was a pale shadow of the Virginia Military Institute in terms of the curriculum and other things that were offered there. So what she's saying here is you have to evaluate people as individuals. You can't just say we don't admit women to the school because women on average are not able to do the physical work or the curricular work. And so VMI now accepts women, and this was an important landmark decision. Here's another one more recently. This Sessions v. DiMaia was decided in 2018. But it was a case that started in the first decade of the 20th century. DiMaia was born in the Philippines and immigrated legally to the United States in 1992. Was convicted of the crime of burglary twice in 2007 and 2009. And despite that, DiMaia had legally immigrated to the United States and had the status of a legal resident, but as a non-citizen. The INS, the Immigration Naturalization Service, sought to deport him a year later in 2010 after the last burglary, under a law that allowed deportation of non-citizens who were in the United States legally but weren't citizens for, quote, aggravated felonies. And that was defined as a crime, a felony crime that used physical force against people or against properties. Now, this is significant in the context of the idea of what Supreme Court justices can do vis-a-vis unpopular minorities, because of course we know that non-citizens don't have any majoritarian power in the United States because they can't vote. So the last line of defense for infringement of the rights of non-citizens who are protected by the Bill of Rights, the 14th Amendment very notably refers not to citizens, but to persons, all persons in the territory of the United States. And you can kind of understand why that would be important, because you could easily have a two-tiered system where only citizens have rights and everybody else who's here doesn't have any rights. And those people are oppressed within our system. So what's happening in this case, DiMaia, is that Justice Ginsburg, who assigns the writing of the opinion, which is a controversial one, it's decided 5-4. And it's Justice Gorsuch, appointed by a Republican president, who breaks the tie in this case by siding with the 4 liberally appointed justices. So Justice Ginsburg assigns the opinion to Justice Kagan. It's only the 6th time that a female justice on the Supreme Court has been assigned the majority opinion and asked to write that opinion. And the law is struck for being vague, that this idea that an aggravated felony, just loosely defined as something that involves physical force, isn't specific enough under, again, the 14th Amendment, the Due Process Clause of the 14th Amendment, to be constitutional. And I've put on the left a kind of timeline of what has been called the Muslim ban, a set of executive orders through which President Trump was able to limit entry of legal residents of the United States, of people who were visa holders that came from a set of countries where the predominant religion is Muslim. That this was happening around the same time that this case was decided. So the first executive order that falls under this category of Muslim ban is signed by President Trump on January 27th, 2017. And this case is decided in April of 2018. So again, here we see the Supreme Court justices in a 5-4 split acting to protect non-citizens within the United States under the 14th Amendment, even though the popularly elected president and a Republican legislature at that time in both houses in 2017 was acting to using its majority power to enact these bans against people from specific countries entering the United States. And finally, a case from 1999, Olmstead v. Elsie, as it's fashioned. This was a landmark case that was focused on the rights of people with mental disabilities to live in their communities. So the Americans with Disabilities Act has a provision within it under Title II known as the integration mandate. So through much of United States history, people who are differently abled mentally or physically, have been segregated from the population of people, the sort of rest of the population, often in government-run institutions. And the Americans with Disabilities Act attempted to change that by, or didn't attempt, made it unlawful or required legally that communities follow this integration mandate to try and eliminate the forced physical separation of people who are differently mentally and physically abled from the rest of the population. Two women, Lois Curtis, or LC here in the case, and Elaine Wilson, had been admitted voluntarily to a psychiatric unit of a state-run hospital in Georgia in the 1990s, but they were held there in isolation for several years following their initial treatments. They had been medically cleared to move to a community-based setting, and their argument in this case was that by holding them, the Georgia Department of Health had violated this provision of the ADA, the integration mandate, which called for bringing people who were differently mentally and physically able back into their communities. The court votes 6-3 in favor of the two women, Lois Curtis and Elaine Wilson, ruling that Georgia had indeed violated the integration mandate of the ADA. And it, as Justice Ginsburg, who writes the majority opinion, she reinforces that there are rights afforded under the United States Constitution to individuals with disabilities of all kinds, including mental illness. She wrote that there had been an unjustified isolation of Curtis and Wilson, and that isolation perpetuated assumptions that persons who are isolated in this way are incapable or unworthy of participating in community life, and that institutional confinement diminished individuals' everyday life activities. So what we see across these three important cases to which Justice Ginsburg was central are the protections of individual people who most likely would not have been able to get a majority of other people in the society to get together and influence the popular branches to work in their favor. So in many senses, or in an important sense, the last recourse for these individuals to have their rights protected under the United States Constitution was this Article III branch. And importantly, Justice Ginsburg, made her way through the biography that you've heard about onto the Supreme Court, and was able to use the particular characteristics of that branch within the structure of our constitutional system to do exactly what it was intended to do when this unique counter-majoritarian power was allocated to it by the founders. And that is to work on behalf of people who have rights in our constitutional system, but cannot make those rights meaningful working within the popularly elected branches. So I hope that conveys some understanding to you of how these three branches work together through the separation of powers, and also the important and particular role that the Supreme Court has, and the way in which we were all benefited, and it, these particular individuals in the cases that I and others have talked about by having someone like Ruth Bader Ginsburg on the court in that particular role. Thank you.
Thank you so much, Dr. Robinson, for being here and for telling us about the history of the Supreme Court and some of Ruth Bader Ginsburg's important opinions on that while she was on the Supreme Court. So now I'm going to turn it over to Ann Brady, who will relay some of the questions that were in the YouTube live chat. And don't forget to put some in the chat if you still have more questions. It's not too late, but we will be ending soon. So any of our panelists will be here to answer those questions.
So I'm going to keep my camera off so people can pop in who would like to answer the questions. The main question that was posed toward the beginning of the time was, could anyone share some of the influences on Ruth Bader Ginsburg's life of her Jewish faith? It was well known that she was very faithful to her Jewish culture, and that she did allow her Jewish faith to influence her work. She had a piece of art in her office that reflected that. If anybody could comment on that.
Yeah, Ms. Page and Ms. Borges, I don't know if you research that, then you can go ahead and jump in. But I saw that in the chat and I was curious, so I looked it up. And she said in an interview, well, it was because she grew up in the shadow of World War II and the Holocaust, which left a big impact on her. And apparently she said that she saw being a Jew as having a place in society in which you're always reminded that you're an outsider. And even as a Supreme Court justice, as a Supreme Court justice, she became an insider. And so Ginsburg said during an interview that it made her more empathetic to other people who were not insiders and who were outsiders. So that's just a little bit, but I hope that answers the question.
I think it does, absolutely.
I'll chime in just a little bit, Olivia, just to provide, I don't know anything very specific about Justice Ginsburg, but I will mention that at that time in the 1940s and 50s, that the influence of the Holocaust, what that had on many Jewish people living in America, they felt a deep obligation to really live out their full life, the potential of their full life. Because of the horrors of what had happened. So there was great pressure on young men and young women to get the best education that they could, to remain faithful, to their religion, to marry well, to marry within their faith and to produce children. This is a big part just from my research, a big part of Jewish culture, particularly in New York City in the late 1940s and into the 50s, to preserve and propagate that faith moving forward because of the destruction of the Holocaust.
Thank you, Mrs. Page. There were not other questions posed at the time, but if any of the other presenters have questions for each other, I think we could. Oh, let's see. We just got a new question. What was RBG's appointment and confirmation process like? Can anybody comment on that? What was RBG's appointment and confirmation process like? She was appointed during the Clinton administration.
Well, I would say that we're hearing a little bit about it right now as Amy Conant-Barrett has been answering questions last week in the hearings. You might have been hearing something called the Ginsburg rule, in which when she would be asked questions during the hearing, she was trying to remain as neutral as she could and making comments that she couldn't present a position on a case that hasn't yet been decided. And so a lot of the commentators on the hearings this week have been talking a lot about the Ginsburg rule. But I think it was also Mrs. De Lima who said that unlike some of the conflict and tension that we've had over the last few nominees, where the vote for confirmation has been very much drawn along partisan lines, Ginsburg was voted in, and I believe it was 97-3, overwhelmingly confirming her. And so there was definitely a majority of support for her nomination, and we haven't seen that for the past couple of nominees.
Yeah, I mean, her first Senate confirmation happened when she was appointed at the circuit court level, and it was uncontroversial. And her tenure prior to the Supreme Court and the federal courts was moderate. Like, she was viewed very much as a moderate. Yeah, there was nothing strikingly notable about her confirmation hearings, and she was, she sailed through.
And if I could just follow up with that, I was watching President Clinton's introduction of her in his nomination ceremony that he had in the Rose Garden, and he did present her as a centrist and as somebody who would be able to bring the division on the Supreme Court together. So it's pretty interesting to watch how, you know, her dissent has evolved, and the way that they say by 2007 she really found her voice as the dissenter. It's not the way that she was presented in that nomination ceremony that was held in the Rose Garden.
People who had desired to have him put forth someone who was more liberal objected actually to her being his nominee. They wanted someone who was more, they thought she was too moderate. Let's see. Any other questions or thoughts from our panel?
Olivia has told me that my slides weren't advancing, so I'll just share them so that if you do any follow-up emails, you can send them along.
Okay, thank you. So I guess if there aren't any more questions, I'll end it here. Thank you so much to everyone who presented, interviewed, was interviewed, and thank you to everyone who's watching this and spending, you know, part of your Saturday learning more about Ruth Bader Ginsburg. And if you want to continue fighting for, to continue Ruth Bader Ginsburg's legacy and fight for what you believe in, please sign up to join the coalition at hwhumanrights.org. Or if you're specifically interested in joining the Youth Education Committee, which is the committee that put this webinar on, you can email me at oliviasulman@gmail.com. So thank you again to everyone who helped plan this and took part in this.
Thanks,
Have a
Olivia.
nice day.
Thank you, Olivia.
Thank you, Olivia.
Thank you.
Thank you so much for organizing. Mr. Steino and Ms. Page and I were saying that the future is so bright if they're in your capable hands for this whole committee. So we're really, really impressed with you young women in taking this on and presenting such a great, great afternoon.
Yeah,
Maya
thank you.
and
Also,
Annalise too.
yeah, I was just gonna say Mariana, Maya, and Nev, they all helped as well. So thanks to them too.
I'd like to say thanks to Melissa Moriarty-Fazio, who looped me into this, and encourage everyone to join the newly formed North Shore branch of the NAACP. You can find us at a good Google of North Shore NAACP. We'd be happy to have you.
Thank you, Dr. Robinson.
Thank
Come
you.
to Northeastern Law School. Fight the good fight.
Thank you, everybody. Great job.
Great.
Bye.
Thank you, everyone.
Bye-bye.
Thank you.
Thank you.